one of the regulars on my show, you know I followed the Australian case of Giggle v Tickle and have had the founder of the women's only app Giggle for Girls, Sal Grover, on here on the platform a few times. Sal went to court, was sued by a man who identifies as a woman, Roxanne Tickle, who claimed he was being discriminated against after being banned from Sal's app based on his gender. Tickle sought damages amounting to $220,000. Sal defended her right to ban a man from her app. But this case isn't just about an app. The judgment impacts all female-only spaces, roles and sports. If women no longer have sex-based rights, watch men exploit it. So last night I saw the post from Sal saying that the verdict from the Australian Federal Court was due out this morning. As I said, I contacted Sal, but she cannot be with us here on the platform due to a contractual commitment. But she will be here on Monday. And this morning, the Federal Court judgment found that although Roxanne Tickle had not been directly discriminated against, he was a victim of indirect discrimination and ordered to pay the app to pay 10,000 Australian plus costs. This is a landmark ruling when it comes to gender identity. And as I said before the break, at its very heart is the case was the ever more contentious question, what is a woman? Joining me now is Jill Ovens, also a regular on the show, co-leader and national secretary of the Women's Rights Party. Jill, good afternoon.
Good afternoon. Terrible decision.
Yeah, I know. And first, before we jump into it, have you spoken with Sal yet?
No, not yet. I did see her comments on Twitter.
Yeah.
So she's determined to fight on.
Yeah, and we'll get to that, Jill, because I mean Australia removing sex from their discrimination legislation and this verdict is a direct result of this, isn't it?
Yes, there's two things really. There's first of all self-sex ID, which allowed Tickle to identify himself as a woman in terms of his birth certificate, etc., which of course we have here in New Zealand. And then in addition to that is the addition of gender identity and expression into the Australian Sex Discrimination Act of 2013, which is what the Law Commission is recommending that we do in New Zealand. And this is exactly what will happen. These blokes who are pretending to be women will come into women's spaces. They're just really testing it, because even if you supply them with gender-neutral spaces, they won't want to use them because they want to prove that they can access women's spaces and that they can pass as women.
And actually, can we go into that a bit more, Jill? As you've just said, here in New Zealand, the Law Commission argues that the Human Rights Act needs to be changed and include people who are transgender, people who are non-binary, and people with innate variations of sex characteristics. And you did say, what is the outcome if that happens?
Well, they have to put their recommendation to Parliament, and then Parliament would have to pass legislation to amend our Human Rights Act accordingly, and that won't happen till next year. However, it's really important that women and men in New Zealand stand up and say, look, we're not going to have this. Because we know from Sal Grover's experience that she set up that women-only, girls-only app, and immediately all these men and their trans allies started bombarding the app and giving it really poor stars of review.
Yeah.
And she had to close it down. It's not even operational. You know, she's having to pay $60,000 Australian, and yet the business venture, which was what she was hoping to do, hasn't been going for 2 years or more.
If over time a growing number of courts rule in favour of gender identity claims, and this is why this was such a important court case, it's more likely, isn't it, Jill, that other countries are going to follow suit?
Well, that's right. The thing is that we belong to the UN convention called CEDAW, which is
can you explain that?
Yeah, it's the Convention for Elimination of Discrimination Against Women. It's been signed up to by 189 countries, including both Australia and New Zealand, And we are not allowed to pass laws that would in any way abrogate the rights of women and men's sex-based rights. That convention does not, and it's an international law, does not mention the word gender. It's all about sex, men and women. And our Human Rights Act has a number of protections, including the first of the list of prohibited grounds of discrimination, but a whole lot of exceptions that allow for employers, for example, or businesses to discriminate on the basis of sex where it's justifiable or where it's needed for public decency or safety in sport.
Yeah.
All those are at risk if men can simply say, I am a woman.
Yeah. Where to now, Jill? Sal had always said when I saw her when she was here on the tour, she would. The next step for her is the High Court. Is that right?
I thought it was the Court of Appeal, but it may be.
Oh, the Court of Appeal. Sorry, no, you might be right.
Yeah.
Court of Appeal. Yeah.
So that court could actually rule that the law needs to be changed and clarified, and so that's what the hope is. Because why should gender trump sex when we're talking about protection, in particular of women and our rights? Not just about spaces or sport, but a whole raft of other sex-based rights that are incorporated into their case, the Sex Discrimination Act, and in our case, the Human Rights Act. For us in New Zealand, we all need to rise up and show by some form of direct action. I mean, I was thinking September the 19th, Suffrage Day. What a perfect day for women and men to get out there and say, hang on a minute. In 1893, we're the first country in the world to not give women the vote. They won the vote. And here we are in 2024 having to defend our sex-based rights. Who would have thought it?
I think that's a great idea, that date, Jill.
Yeah. As our sisters in the UK say, it's bollocks.
Yes.